The sound that woke me wasn't an alarm, or a knock, or even shouting. It was absence, the kind that hits your chest before your brain catches up. The driveway was empty, and for half a second my mind refused to accept what my eyes were telling it. The patrol car that had been there every morning for years. The marked unit with city seals and reflective striping. The one thing that never moved without my consent was gone. Not repositioned, not borrowed, not reassigned. Just gone like someone had erased it out of the frame while I slept. I stood there barefoot on cold concrete, heart already accelerating, knowing with absolute certainty that this was not a department recall or a clerical mix-up. Squad cars don't disappear quietly, and they definitely don't vanish from an officer's private driveway without paperwork, radio traffic, or a call from a supervisor. Someone had taken it, and they hadn't asked. Someone had decided that a police vehicle, owned by the city and assigned to me, was something they could touch. That realization landed harder than any shouted threat ever had. Before we move forward, drop a comment. Where are you watching from? Because the moment you understand what it takes to move a marked squad car without authorization, you also understand just how far this was about to go. I didn't shout or swear or panic, because training kicks in long before emotion does, and the first thing I did was scan for evidence that shouldn't exist. No broken glass, no debris, no tire marks from a rush job, just the faint outline where the cruiser had been sitting, cleanly removed like it belonged to someone else. That kind of precision doesn't come from joyriders or opportunists. It comes from a tow operator following an instruction they believe is legitimate, which meant someone had made a call, given an address, and claimed authority they did not have. That's when the name surfaced without effort, not as a guess, but as a certainty. The same way you recognize a pattern you've already been warning yourself about. HOA Karen. She hadn't liked the car from the day she moved in, hadn't liked what it represented, hadn't liked that it sat there every night, quietly contradicting her sense of control. I'd seen the notes, the passive-aggressive warnings slipped under the wiper, the language about aesthetics and compliance and unauthorized presence, all wrapped in polite fonts meant to disguise hostility. I ignored them because police vehicles are not decorative choices. They're operational assets, and they're protected by law for a reason. But HOA Karen didn't see a city-owned emergency vehicle. She saw an obstacle to her authority, something she hadn't approved, and therefore something she believed she could remove. The longer I stood there, the clearer it became that this wasn't a misunderstanding. It was an action taken with intent. I went back inside, grabbed my phone, and called my sergeant, already bracing for the tone that would tell me how serious this was. He didn't ask me if I was sure, didn't suggest I check again, didn't sound confused at all, and that was when my stomach dropped. He told me the unit had been towed. Not reassigned, not serviced, towed by a private company acting on a call logged under HOA authority. There are moments in law enforcement when the line between personal insult and criminal act becomes unmistakably clear, and this was one of them. A marked police vehicle is not a suggestion, not a loophole, not a gray area. It is city property, and removing it without authorization is theft. The word theft carries weight when you wear a badge, because you don't get to pretend it means something softer when it's inconvenient. I felt anger then, but it was cold and focused, the kind that narrows everything down to process and consequence. I drove to the impound lot in my personal vehicle, already documenting the timeline in my head, already knowing this wasn't going to end with a fee and an apology. The tow yard manager tried to speak in the language of routine, as if this was just another car, another call, another transaction he could smooth over with paperwork. That illusion collapsed the moment he admitted the tow was executed on the word of an HOA president without verification. When he said that out loud, the air changed. Because now it wasn't just HOA Karen's problem, it was his too. I didn't raise my voice. I didn't threaten. I simply stated facts, the kind that don't need emphasis to be understood. The vehicle he had taken was owned by the city, clearly marked, and protected under state law, and releasing it was no longer a courtesy, but a requirement. When the keys were finally handed over, I inspected the damage in silence, each scrape and gouge becoming another line in a report that would not be ignored. By the time I parked the cruiser back in my driveway, neighbors were watching, some confused, some curious, all of them unaware they were about to witness a line being drawn. The next morning, I stood in the chief's office with photographs, timestamps, notes, and a paper trail that pointed in exactly one direction. He didn't interrupt me, didn't minimize it, didn't ask whether I wanted to pursue it, because that decision was never mine to make. This wasn't about feelings or neighborhood politics. It was about a civilian causing the unauthorized removal of a law enforcement vehicle. When my chief said the words "grand theft auto" out loud, there was no drama in his voice, just finality. HOA Karen had crossed out of her world and into ours. Everything she thought protected her. The bylaws, the titles, the clipboard authority she'd been swinging around, vanished the moment she touched city property. What she thought was enforcement was about to be reclassified as a felony, and while she likely expected a warning, maybe a stern letter or a meeting request, what she triggered instead was an investigation. The kind that doesn't care how confident you sounded on the phone or how justified you felt in the moment. As I left the station that morning, I knew this story was no longer about a towed car. It was about what happens when someone confuses control with power and learns the difference in real time. Authority isn't something you announce. It's something that exists long before anyone thinks to challenge it. And that's what made what happened next so absurd. I didn't wake up one day and decide to bring a police vehicle into a quiet neighborhood to provoke anyone. It had been part of my life for years before HOA Karen ever learned my name. The take-home unit wasn't a privilege or a flex. It was a department policy rooted in response time, visibility, and deterrence. The kind of thing cities implement because it works even when nobody is thinking about it. For over a decade, I'd driven marked units home, at the end of shifts, parked them in driveways, on streets, under streetlights, in neighborhoods far louder and far more volatile than this one, and never once had anyone questioned whether I belonged there. That wasn't luck, it was clarity. A marked patrol car sends a message that doesn't need translation, that help is close, that the city hasn't forgotten you, that someone is on duty even when it's quiet. Riverside Gardens had been that kind of place for a long time. The kind of neighborhood where routine mattered more than rules and common sense did most of the work without being asked. Families waved, kids rode bikes past the driveway. Neighbors asked about shifts or thanked me for responding quickly when something went wrong down the block. Nobody ever saw the cruiser as an eyesore because nobody saw it as decoration. It was just there, the same way mailboxes and trash bins and porch lights were there, part of the environment rather than a statement. The HOA existed, but it existed in the background. Mowing schedules, basic maintenance, newsletters that most people skimmed and forgot. A structure designed to manage the boring things nobody wanted to argue about. That balance worked because nobody tried to weaponize it. Then HOA Karen arrived, and everything about that balance made her uncomfortable. She didn't like that the neighborhood ran on understanding instead of enforcement, didn't like that people made decisions without asking permission, didn't like that certain things simply existed outside her influence. From the beginning, she treated the HOA not as a service role, but as a platform, something that could elevate her preferences into obligations for everyone else. She talked about standards the way some people talk about morality, rigid, self-appointed, and allergic to nuance. The patrol car became her fixation because it represented authority she didn't control, a symbol that sat in plain view every night and quietly contradicted her assumption that she was the highest-ranking presence on the street. To her, it wasn't a city asset assigned to an officer, it was a challenge. She never asked me about it directly at first, never knocked on the door or tried a conversation, because conversations invite answers, and answers can shut down fantasies. Instead, she left notes, impersonal and declarative, written as if they were final notices rather than suggestions, invoking rules without citations and consequences without jurisdiction. Commercial vehicle, unauthorized, non-compliant, words chosen carefully to sound official without being accurate. I ignored them because there was nothing to engage with. Police vehicles are not commercial vehicles, not under HOA bylaws, not under state code, not under any interpretation that survives basic scrutiny. They are government emergency vehicles, exempt by design, protected by law, and treated differently for reasons that matter. I didn't assume ignorance on her part at first. I assumed persistence without understanding, the kind of thing that usually resolves itself once the management company steps in and clarifies. So I made the call, not to escalate, but to document. The property manager confirmed exactly what I already knew, that the vehicle was permitted, that Karen had been told as much, that there was no issue from the HOA's standpoint. That should have ended it. It didn't, because the problem was never the rule. The problem was that authority existed somewhere she couldn't reach. When she decided to act anyway, she wasn't enforcing anything. She was asserting herself, betting that confidence and paperwork tone could substitute for actual power. That bet only works when nobody calls it. She didn't understand how layered authority actually is, how HOA governance sits at the very bottom of a hierarchy that includes municipal law, state statute, and federal protections. She didn't understand that police vehicles aren't personal property you can inconvenience to make a point. They're operational assets tied to public safety. Most importantly, she didn't understand that intent matters. When you knowingly act without authority after being told you don't have it, ignorance stops being an excuse and starts being evidence. That's the line she crossed when she picked up the phone and ordered a tow. From her perspective, it probably felt decisive, the culmination of weeks of frustration, a moment where she finally forced compliance instead of being ignored. From a legal perspective, it was a civilian causing the removal of city property without authorization. The fact that the property was clearly marked only made it worse. There was no plausible deniability, no confusion about ownership, no ambiguity about function. Anyone looking at that vehicle could tell what it was and who it belonged to, which meant her decision wasn't accidental, it was deliberate. Authority in law enforcement isn't loud, it's procedural, and once that procedure starts moving, it doesn't stop for embarrassment or regret. By the time the chief got involved, this wasn't about me or my driveway or even the damage to the vehicle, it was about precedent. If a civilian can order the tow of a marked police unit because they don't like how it looks, then the entire structure that keeps those vehicles operational collapses. That's why the response was swift and formal, why detectives were assigned, why statements were taken and records pulled. The system reacted because it had to, not because anyone wanted to make an example out of her. Examples happen naturally when someone insists on learning the hard way. Karen had spent weeks acting as if HOA titles gave her a level of control they never did, confusing administrative convenience with legal authority. The moment she touched city property, that confusion stopped being theoretical. It became a case. And cases don't care about intentions dressed up as enforcement. They care about actions, knowledge, and consequences. The background mattered because it showed this wasn't a snap decision or a misunderstanding. It was a pattern that escalated despite warnings. She wasn't new to the information. She was new to being told no. That distinction is what separated a complaint from a charge. By the time the investigation moved forward, the story had already shifted from neighborhood dispute to criminal liability, and nothing she said afterwards could change the order of events. Authority had been clear long before she challenged it. She just chose to pretend it wasn't there. HOA. Karen didn't wake up one morning and decide to tow a squad car. She climbed there step by step, fueled by a system that rewards confidence over competence and paperwork over accountability. HOAs don't start as weapons, they start as committees, but committees become dangerous the moment someone mistakes access for authority. Karen learned quickly that most people don't challenge official-sounding language, that a clipboard and a title can silence neighbors who don't want conflict, and that fear of fines works better than actual rules. She exploited that hesitation, leaning into the gray areas where residents assume someone else has already checked the legality, already verified the power behind the request. That assumption is the crack she pushed through. The HOA structure gave her just enough leverage to feel untouchable, but not enough oversight to stop her when she went too far. Property managers defer, boards rubber stamp, neighbors disengage, and suddenly one person's preferences masquerade as community standards. Karen framed everything as compliance, but compliance to what was never clearly defined. Rules were selectively cited, warnings selectively enforced, and exemptions selectively ignored when they conflicted with her sense of control. The patrol car wasn't the first thing she fixated on. It was just the most visible. Before that came complaints about noise, about parking, about kids playing too late, about dogs existing too loudly, each one framed as a violation rather than a reality of shared space. She used the HOA as a megaphone for personal discomfort, escalating minor annoyances into official grievances that carried implied consequences. Most people backed down not because she was right, but because pushing back felt exhausting. That exhaustion is how abuse hides in plain sight. Karen learned that if she spoke with certainty, people assumed she had backing, and if she acted decisively, people assumed she had permission. The management company told her explicitly that she did not, but that didn't register as a boundary. It registered as resistance. To someone like Karen, resistance isn't a stop sign. It's a challenge to overcome. She began treating the HOA as an enforcement arm rather than an administrative body, skipping process and inventing urgency where none existed. By the time she picked up the phone to call the towing company, she wasn't thinking about bylaws or legality. She was thinking about winning. She believed the structure would protect her, that the ambiguity of HOA authority would blur responsibility enough to shield her from consequences. That belief is common among people who abuse small amounts of power, the idea that systems exist to absorb blame while they enjoy control. What she didn't understand was that HOA authority is derivative. It exists only within limits set by higher law. It cannot override city ownership. It cannot authorize seizure of government property, and it certainly cannot impersonate enforcement powers it doesn't possess. Karen blurred those lines intentionally, presenting herself to the towing company as an HOA president with the authority to order removal. She relied on the towing company's willingness to accept claims at face value, another weak link in the chain of accountability. That chain broke the moment a marked police vehicle was hooked up and dragged away. The abuse wasn't just the tow, it was the presumption behind it, the assumption that her interpretation mattered more than reality. HOA Karen treated the rules as tools, not constraints, bending them to serve her narrative rather than the community's needs. She ignored context, ignored exemptions, ignored explicit instructions from management because they interfered with her objective. That's how abuse operates inside bureaucratic structures, quietly at first, then suddenly, spectacularly. Each unchecked action reinforces the belief that the next one will also go unpunished. By the time she escalated to involving a third party, she was operating on momentum, convinced that the system existed to validate her decisions after the fact. She didn't consider that every call leaves a record, every request creates liability, and every misrepresentation compounds the offense. The HOA structure gave her proximity to authority, but not immunity from law, a distinction she either didn't understand or chose to ignore. When the tow happened, the abuse crossed from administrative overreach into criminal territory because it involved deprivation of property without right. That transition is invisible to people who think power is about titles, but obvious to anyone who understands how law actually functions. Karen's actions exposed a fundamental flaw in how HOAs operate. When oversight is lax, that one person's obsession can metastasize into systemic harm. The system didn't empower her to tow a squad car, but it failed to stop her from trying. That failure didn't absolve her. It documented her intent. Every ignored warning, every dismissed clarification, every step she took despite being told no, built a trail that led directly back to her. Abuse of HO. A power often hides behind process, but in this case, the process itself became evidence. What she thought was enforcement was actually impersonation, and what she thought was authority was just noise amplified by silence. The moment law enforcement stepped in, that noise collapsed into facts, and facts don't bend for ego. The moment my squad car vanished from my driveway, the situation stopped being a neighborhood annoyance and became a measurable crime, because absence is louder than confrontation when the thing missing is government property. I didn't shout, I didn't speculate. I verified, Because discovery isn't about panic, it's about precision. I checked the driveway twice. Not because I thought it would magically reappear, but because my brain needed to lock onto the reality that something marked, logged, and assigned by the city had been removed without authorization. That realization sharpened everything. I contacted my sergeant, not to complain, but to establish record, time, and chain of custody, because proof begins the moment you stop assuming and start documenting. Within minutes, the absence gained a paper trail. Tow logs don't lie, dispatch timestamps don't improvise, and city vehicle assignments don't wander off on their own. When the tow company confirmed they had the vehicle, the story stopped being hypothetical and became physical. There was a location, a time, a requesting party, and a justification, all of which could be examined. That's where Karen's confidence began to crack, even though she didn't know it yet. Every step she took relied on the assumption that no one would slow down enough to look closely. The impound lot was quiet, but quiet places keep records better than loud ones. The manager didn't argue the tow happened, he justified it, and justification is admission wrapped in explanation. He said an HOA representative requested removal for a violation, which narrowed the scope immediately. HOA representative isn't a legal shield, it's a claim that must be proven. I photographed the vehicle before moving it, not because the damage was severe, but because proof doesn't care about severity. It cares about existence. Scratches, undercarriage marks, misaligned panels, each one turned a bad decision into a quantifiable loss. Those photos weren't emotional, they were transactional. When I drove the car back, I didn't feel relief, I felt clarity, because now the evidence was complete enough to stand on its own. The next morning wasn't about confrontation, it was about synthesis. I laid out the notes Karen left, the HOA manager's prior clarification, the tow company's records, the timestamps, and the photos, not as a story, but as a sequence. Sequences are harder to argue with than narratives. My chief didn't need persuasion, he needed confirmation, and confirmation was already on the table. A marked police vehicle, exempt from HOA restrictions, removed at the request of someone explicitly told she lacked authority. That's not confusion, that's defiance. The investigation didn't chase possibilities, it followed documents. Phone records showed the call came from Karen. Tow logs showed the request was framed as enforcement. HOA management confirmed she'd been warned. The pieces didn't just fit, they locked. Discovery in cases like this isn't dramatic, it's cumulative. Each small verification tightening the outcome until there's nowhere left to retreat. Karen's claim of authority evaporated under scrutiny because authority leaves fingerprints when it's real. She had none. What she had was insistence, and insistence doesn't hold up in court. When detectives knocked on her door, they weren't asking what she thought happened, they were confirming what already had. Her explanations shifted, and shifting explanations are admissions in slow motion. She said she believed, then said she assumed, then said she enforced, each verb weaker than the last. Belief isn't authorization. Assumption isn't permission. Enforcement without authority is theft with paperwork. The value of the vehicle mattered, but the intent mattered more. She didn't accidentally tow a squad car. She ordered it removed after being told not to. That's the line discovery draws in bold ink. Proof doesn't ask whether someone felt justified. It asks whether they were. Karen wasn't. By the time the evidence was compiled, the case no longer belonged to the HOA, the towing company, or even me. It belonged to the state. At that point, the process stops being personal and starts being inevitable. Every document, every call, every photo pushed the situation forward without emotion because proof doesn't escalate. It advances. Karen had relied on ambiguity to protect her, but discovery destroys ambiguity by replacing it with sequence, record, and verification. Once that happens, there's no space left for narrative gymnastics. The story collapses into facts, and facts don't negotiate. The confrontation didn't happen in a driveway or over a fence. It happened the moment the law stopped listening to Karen's confidence and started listening to the evidence, because that's where false authority always collapses. Karen expected argument, maybe mediation, maybe another chance to explain herself into control, but what arrived instead was certainty wearing a badge. When detectives stood at her door, there was no shouting, No spectacle, just calm questions that carried weight because they already knew the answers. She tried to speak first, and that alone revealed how she saw power as something you seize by talking before anyone else does. The detectives didn't interrupt. They let her talk, because the fastest way for someone abusing authority to collapse is to let them explain their reasoning out loud. She repeated the same phrases she'd used on neighbors, on the towing company, on the HOA, but this time the words landed differently. This wasn't a community dispute. It was a criminal inquiry. When they told her the vehicle was city property, her face tightened, not with surprise, but with resistance. She didn't deny ordering the tow. She reframed it, because people like Karen don't retreat, they relabel. That reframing failed instantly. The detectives didn't debate HOA bylaws. They cited state code. They didn't ask if she felt justified. They asked if she had authority. She said president. They said irrelevant. That exchange stripped the illusion clean, because titles don't override ownership, and ownership doesn't bend to personal preference. When they explained the value of the vehicle, the conversation shifted from irritation to fear. Felony isn't a word that sounds theoretical when it's attached to a dollar amount and a statute number. Karen's confidence cracked in stages. First indignation, then confusion, then panic disguised as outrage. She asked how this could happen, as if reality had betrayed her, rather than her actions catching up. The arrest wasn't dramatic, but it was public enough to matter. Neighbors noticed. Phones came out. Whispers replaced assumptions. The same community she tried to control watched her authority dissolve into procedure. Handcuffs don't care how loud someone was yesterday. The HOA board moved fast after that, not out of principle, but out of survival. Emergency meetings, statements drafted, apologies issued, because proximity to scandal feels dangerous when the spotlight turns. Karen's removal was immediate, decisive, and quiet, which told everyone exactly how disposable her authority had always been. She wasn't the system. She was a liability once the system was examined. Word spread faster than any official notice. The story wasn't framed as a misunderstanding. It was framed as a warning. Someone tried to enforce control where none existed, and paid for it in real consequences. The public collapse didn't require shouting, because the facts spoke louder than any confrontation ever could. Karen didn't argue on the courthouse steps. She avoided cameras. She didn't rally supporters. She hired a lawyer. That shift, from loud enforcement to silent defense, was the clearest indicator that the balance of power had flipped. In court, the language changed completely. HOA rules vanished from the conversation, replaced by criminal liability and restitution. Her attorney tried to frame intent as confusion, but confusion doesn't survive documented warnings. The prosecutor didn't raise his voice. He laid out the sequence, step by step, and sequence is ruthless. Ordered tow. No authority. City property. Damage incurred. Interference established. That rhythm didn't leave room for interpretation. When Karen accepted the plea, the collapse finalized. Not because the sentence was extreme, but because it was real. Jail time, probation, fines, restitution, all consequences that don't exist in HOA fantasyland. The public part of the collapse ended when she left the neighborhood. No farewell, no redemption arc, just a for sale sign and a moving truck. The absence lingered longer than her presence ever did. The confrontation wasn't a shouting match. It was a transfer of control back to where it belonged, from ego to law, from assumption to fact, from clipboard authority to actual consequence. Karen didn't lose because someone opposed her loudly. She lost because someone documented quietly and let the system do what it was designed to do. That's how public collapses really happen, not with explosions, but with silence following accountability. Retaliation didn't come as anger or vengeance. It came as expertise applied with patience, because once the confrontation ended, the real pressure shifted into systems that Karen never understood and never respected. The moment the charge was filed, the narrative stopped being emotional and became procedural, and that's where experience matters more than volume. This was no longer about a neighbor dispute or an HOA power trip. It was about correcting damage, reinforcing boundaries, and making sure the same abuse could not repeat itself under a different name. The police department moved first, not loudly, but deliberately, because institutions respond best when they're allowed to do their job without interference. Internal reviews were conducted, not to question the officer, but to document the failure points that allowed a marked patrol vehicle to be taken at all. Those reviews weren't symbolic, they were corrective. Policies were clarified, written guidance distributed, and towing companies were reminded in unmistakable language that verification is not optional when government property is involved. Expert retaliation doesn't seek headlines, it seeks prevention. The towing company learned that lesson quickly. Removal from the approved rotation wasn't punishment for optics, it was consequence for negligence, and every other operator in the city noticed. The message traveled quietly through contracts and compliance meetings, which is how professionals communicate deterrence. On the HOA side, the response was surgical. The board didn't just remove Karen, they dismantled the pathways she had used to act alone. Authority was restructured, approvals centralized, and enforcement procedures rewritten to require verification rather than assumption. That wasn't an apology move, it was a liability move, because once the law is involved, ignorance stops being a defense. Experts don't yell, they redesign systems so the same mistake becomes impossible. The new board leadership understood that immediately. They didn't posture, they listened. They didn't issue blanket statements, they issued specific corrections. Every resident received written clarification that emergency vehicles, government vehicles, and take-home patrol units were protected under law and exempt from any neighborhood restrictions. That document mattered more than any meeting because it replaced rumor with record. At the department level, the chief used the incident as instruction, not spectacle. Roll call discussions focused on rights, documentation, and the importance of immediate reporting when authority is challenged improperly. The story circulated internally not as gossip, but as case study. Expert retaliation is about turning disruption into education. The officer didn't become a symbol, he became a reference point. Other officers spoke up about similar pressure, not because they wanted attention, but because the environment had shifted from silence to support. That shift is powerful because it prevents escalation before it begins. Legal follow-through reinforced the lesson further. Restitution wasn't about money, it was about acknowledgement. The fine wasn't about punishment, it was about deterrence. Community service wasn't about optics, it was about grounding someone who had forgotten that authority flows from consent and law, not self-assignment. Karen's case didn't fade quietly in legal circles, it became precedent. Not published precedent, but operational precedent, the kind attorneys reference when advising boards and management companies on risk. That ripple effect is how expert retaliation works. It spreads laterally through awareness rather than vertically through fear. Back in the neighborhood, the atmosphere changed subtly but permanently. People didn't become louder, they became calmer. Control wasn't something one person wielded anymore. It was something distributed across clear rules and mutual respect. The visible patrol vehicle regained its original purpose, not as a point of contention, but as reassurance. Presence without conflict is the strongest form of authority. The officer didn't change routines, didn't seek recognition, didn't adjust behavior to accommodate past overreach. That consistency mattered because it demonstrated that the response wasn't reactive, it was corrective. Experts understand that stability after conflict is what restores trust. Karen's retaliation attempts ended where expertise began. Every avenue she once used, intimidation, misrepresentation, pressure through third parties, had been closed not by force, but by clarity. She didn't lose to a person, she lost to process. That distinction matters because people can argue with people, but they can't argue with documentation. The final layer of expert retaliation came in silence. No follow-up drama, no lingering disputes, no re-litigation in public spaces. Just corrected systems, informed communities, and boundaries reinforced by professionals who understood the weight of responsibility. That's the kind of retaliation that lasts. The kind that doesn't invite counterattack because it removes the battlefield entirely. Victory didn't arrive with applause or celebration. It arrived with silence, and that silence was heavier than anything Karen had ever heard. There were no more notes on windshields, no more anonymous complaints, no more phone calls pretending to speak for a community that never authorized her. The driveway stayed exactly the same. The squad car parked where it always had been, unmoved, unchallenged, and suddenly invisible again, which was the point all along. When power abusers lose, they don't lose loudly. They lose by being rendered irrelevant, and that is the most complete defeat possible. Karen's house went dark before the moving truck even arrived. Blinds drawn, lights off, a quiet retreat that matched the way her authority had evaporated. Neighbors didn't gather to watch her leave because there was nothing left to see. No one needed closure speeches or victory laps because the outcome spoke for itself. The neighborhood resumed its rhythm, children outside, dogs barking, cars parked where they belonged, and for the first time since her arrival, nobody felt watched. That absence of tension was the real win. Inside the department, the incident stopped being discussed because it no longer needed to be. Lessons had been absorbed, systems corrected, and boundaries reinforced. When something is handled properly, it doesn't linger, it settles. The officer went back to work, back to routine calls, back to nights and mornings that had nothing to do with HOA letters or towing receipts. The patrol car still bore its small scars underneath, scratches that only someone looking closely would notice. Quiet reminders that overreach always leaves evidence somewhere. Those marks weren't fixed immediately, not out of neglect, but because they served a purpose. They were proof that the system had been tested and held. New neighbors moved into Karen's old house, polite, unassuming, and uninterested in policing anyone else's driveway. They waved. They kept to themselves. They understood without being told that some lines aren't drawn by committees or clipboards, but by law and consequence. The HOA meetings became shorter, calmer, procedural in the way they were always meant to be. No speeches, no power plays, no personalities dominating the room, just maintenance, votes, and adjournment. Control returned to where it belonged, spread thin enough that no single person could weaponize it again. The towing company never called back, never questioned, never tested the boundary a second time. They didn't need to. The cost of getting it wrong once had been enough. Sometimes deterrence doesn't need threats. It just needs one clean example. The chief never mentioned Karen by name again. He didn't need to. The point had already landed. Authority doesn't come from demanding compliance, it comes from understanding responsibility. And Karen had confused the two until the law corrected her. Months later, when the story came up in casual conversation, it was always brief. She towed a squad car. That didn't end well. And then the subject changed, because there was nothing left to unpack. That's what real resolution looks like. No ongoing feud, no lingering drama, no attempts to rewrite history. Just a quiet acknowledgement that a line was crossed and firmly redrawn. The driveway stayed quiet. The cruiser stayed put. And the person who thought she could command consequences without authority disappeared from the picture entirely. Nobody argued after that.